Hello, everyone. Welcome to our webinar, actually the third webinar that we've done with regard to the budget bill that passed April 1 and the changes to our state's Medicaid program that will begin implementation 1 month from today. So October 1 is the start of the phase-in of these new rules. As we're going to see, they are going to be phased in, and we're going to talk about how those rules are coming in and what you can do about it. This is our firm. This is our commercial. Pierro, Connor & Strauss is a firm that works in the areas of estate planning, elder law, business succession planning, and related fields. We have offices in Albany and New York City, our primary offices. We also have affiliate offices in Lake Placid, Utica, Long Island, New Jersey, Massachusetts, and Florida. So this is our field, and we try to keep track of what's going on in the law. Lately, that's become a bit difficult. The changes seem to be frenetic in all types of areas, tax areas, that all the impending changes coming with the election that's impending, and as we're going to see, changes that are already implemented in New York State in the Medicaid program. And just to give you a backdrop quickly, this was as a result of a budget deficit that was part of the 2020 governor's budget. The budget bill called for cuts of $6.2 billion. That was a deficit number, a good chunk of that coming in the area of Medicaid. So the governor appointed a Medicaid redesign team, and this, if you're part of this world, you know it was part due. It was the second Medicaid redesign team. They came up with a series of proposals and a report in a very short period of time, I think about 45 days. And part of that was cutting the Medicaid home care program. And so what we're going to look at today is how those cuts were implemented in the budget bill, how they have been rolled out or are being rolled out, what the changes mean to you if you're an advisor or if you're an individual consumer who's looking at Medicaid as a potential funding source. And of course, Medicaid covers nursing home care. Most people know that. But in New York, Medicaid also has a very rich home care program, and we traditionally have been a leader nationally in Medicaid home care services. So what does it mean to us? What are the knowns, the things that we know? What are the things we know we don't know? And of course, that third tier of knowledge, we don't know what we don't know. So there will be more changes. We'll keep coming on with webinars as the changes roll out and implementation happens. And as we're going to see, there are some proposed regulations. The key to this is our clients want to age in place. As my mom said, the only way I'm leaving our home, which we've had for 50 years, is feet first. And that's a lot of our clients' desire, is to stay in their home, hunkered down. But in aging, that means at times having to bring services into the home. The only program out there publicly that provides that home care service is Medicaid. And so let's take a brief poll, if we may. And just to get a gauge on who you are in the audience today, our viewers, are you a person that already has Medicaid, person that anticipates needing Medicaid, a caregiver of someone who may or may not, who may in the future or may be now on Medicaid, and a professional? And there are the results. So we have a number of you who are professionals, and we kind of anticipated that. This is a very technical topic. We do have some consumers and a few caregivers. So we're going to keep this as light as we can for those non-professionals, but give you enough depth so that the professionals can get a good gauge on what's coming in terms of these new rules. As I mentioned, October 1 was the date that the April 1 budget bill put as a target. Why was that? That was because of our pandemic. There was federal legislation that prohibited states from imposing more restrictive rules during the time of COVID. And so they postponed the effective date until October 1. And now we're going to talk about the critical dates that are being proposed. October 1 was the application date. It's still part of the rule making because it's going to be the transfer date. But applications, as we're going to see, are going to be a little bit later. And we're going to be phasing in what we call a look-back period, which we'll explain to you fully as we go through the presentation. So The first rule that you need to know is that any transfer made on or after October 1 of 2020 will be penalized, will generate a penalty for Medicaid home care services. So there is a premium, and we have been dealing with a lot of clients trying to get things done under the gun. Very often we use trusts, we call it the Medicaid Asset Protection Trust, to get assets moved in such a way that you can qualify for Medicaid when you need it. Up until now, we haven't had a look back or penalty period for home care services, but any transfer made on or after October 1, as we will see, is going to generate a penalty if it's made within the look back period. We'll get to that in a moment. The penalty begins to run, and this is kind of the hard part for home care services. We've been dealing with penalties and look backs, 60-month look back for nursing home care for many years. We have now a 30-month look back for home care services. When does a person have the ability to run that penalty? When does it begin to run? If you're in a nursing home, Frank, that's pretty easy. You have a penalty that runs when you're in the nursing home, otherwise eligible for Medicaid, and you file your Medicaid application. Well, now you have to be otherwise eligible financially, you have to be eligible from a medical perspective, and you have to file your application. But in a home care setting, how do you determine that? We're going to talk about that, what we're thinking Department of Health is going to accept and Departments of Social Services are going to accept as verification that you are otherwise eligible from a medical perspective, because you have to hit both bogeys, financially eligible and medically eligible. And in a home care context, it's not as easy as, hey, I'm in a nursing home. I'm in my home. How does DSS know that I'm otherwise eligible? So Medicaid eligibility is usually determined at the time of application. Applications filed prior to October 1, we know will be processed using existing rules. We've been told that. And so all of the current rules, both medical and financial, are going to be done in the old rules for anything filed prior to October 1. Question becomes, will existing Medicaid beneficiaries, if you've gotten in under the old rules, will they be eligible post-implementation, or will there be new rules that are superimposed on that Medicaid recipient? We believe, and DOH has given an indication, that if you are already on Medicaid, you will be grandfathered in, and they will not be going back through all the existing Medicaid recipients. I know if anyone's listening from DSS, that's a sigh of relief. But you won't. And this is all best information. We don't have final rules or regs yet. Best information is they're not going to go back and reassess, that you'd be grandfathered in under the old rules. So whether that applies to all of the standards or just the financial criteria, we're not quite sure yet, but they've indicated that they are going to grandfather in existing applications. So whenever you have statutory changes, the framework is the legislature passes the legislation, the governor signs it, the agencies implement it. And when they implement it, they issue regulations. So on July 15th, the Department of Health issued proposed regs, and the proposed regs are out for comment. It's a 60-day comment period, which closes September 14th. So in 2 weeks, the comment period will close, and following that, the department will issue final regulations. So the final regs will be when we come back on and say, okay, here are the real rules on the final reg basis. And until then, we're kind of floating with proposed regulations and guidance from the Department of Health as best we can discern it. And anybody that deals with state bureaucracy, you know that there's not a very free information flow. And we've faced this, and I know the agencies at the county levels face this, but we're going to go with best guidance and the proposed regs and give you what we have as of today. We will come back with final regs at some point and give you the final answers as to all of these questions. So the question becomes, what programs does this apply to? And Frank, you do virtually all of our firm's Medicaid applications, and we have a lot pending right now because people want to get in under the old rules, and rightly so. But the New York Medicaid program is a bit more complicated than most states because we have a variety of different programs, and it's going to be important to know the distinctions even more so now under these new rules.
Right. So on the screen, right, you have different lists of different types of programs that get offered by the New York Medicaid program. So we deal a lot with clients that are in the personal care services program. We also heavily use the consumer-directed personal assistance program for our more rural people, or our clients that have family members or close friends that want to be their caregivers. And in a lot of places, that's the only way we can get a home care case to work, because there aren't agencies available to staff those cases.
Right.
We deal a lot with the managed long-term care plans, which is number 6 on the screen. We think those are probably covered. We have everything we've been led to believe is the personal care services program and the consumer-directed program will fall under these new rules and regulations.
Consumer-directed was actually the target of a lot of legislation, and they've been in litigation with the state. I had Elizabeth Martin, who was the director of our local consumer-directed program, the Choices program here in the Capital Region. I know we have people on the webinar from around the state, but she has just moved from consumer-directed choices to living resources. So she was on our radio show last Saturday with Fred Ehrlich, the outgoing CEO, and we had a great show. But she was talking about the budget cuts that they faced and the fact that they did get an injunction against the implementation of a $75 million cut to consumer-directed CDPAP, but it was based on a technical ground that the rulemaking was improper. And so she expects, as does the consumer-directed industry, that it's going to come back. The state's going to come back with further cuts to CDPAP, which in upstate regions we use is a lifeline because agencies just don't have the wherewithal to recruit, hire, and pay people a wage that is just not sufficient to maintain a workforce. So people find their own help with consumer-directed. That's going to be chopped. Personal care is going to be chopped. The one program that we use frequently, Frank, is the NHTD program.
Right, which we use a lot for our seniors that have cognitive issues or require more of a full plan of care, where it's not necessarily the skilled things that they need all their assistance with. They might need monitoring or help with other ADLs or IADLs that don't require that hands-on personal assistance. So again, under what we know right now, the NHTD program wouldn't be subject to these new regulations, which is great for those people that are on that program, as well as the TBI waiver or the OPWDD waiver, which we use occasionally if we have the right case for that.
And knowing how to use the proper program is vital to using Medicaid home care in New York State. It isn't just financial eligibility, financial criteria. It's knowing the program and what the needs of the individual are and how to match those needs to the appropriate home care regimen. So these are going to be on the block. NHTD is a major exception. And we will be probably using that more frequently, as most people will, if they leave it out of the coverage of these new eligibility rules. So here's where the new rules, we're not quite sure when this is going to be implemented, but DOH has indicated these are changes that will come in January, not October 1, but January 1. And they're changing the medical qualifications, the criteria for an individual to become Medicaid eligible. Right now, it's 2 ADLs, activities of daily living. And if you can't perform 2 ADLs, then you are eligible to receive home care services. They're bumping that up to 3 ADLs. And that's a major change, 50% more in terms of the disability that you need to have in order to qualify for Medicaid home care. For people with dementia, Alzheimer's, there is a need for at least supervision with more than 1 ADL, so 2 or more. That means that if you have cognitive impairment, you now are out of certain services that you used to be able to qualify for. And as you know, early intervention, getting services in the home before there's crisis and you have a very significant need, and helping people to maintain at home is key. It's going to make that even more difficult. So people receiving personal care get assessed. If you are, this is kind of where it comes in, we're talking to our clients. If you have an opportunity to apply for Medicaid home care services now, and we know a lot of people are reluctant to apply for Medicaid, number one, because it has a certain stigma to it, and to bring people into their home, number two. but there is motivation now to get grandfathered in, get your application in, get the services, get assessed under existing rules, develop your baseline, and then as time goes forward, you can increase services with a request as your needs increase. So some motivation there for people to get started. This is going to be a major change as well. They're going to have an evidence-based, validated assessment instrument. A lot of words. New tool. A document that's going to try to make the assessment of care uniform. That's not due out till April 1st. But in the meantime, they're going to be using this when it comes out in the initial assessment, which is the Maximus assessment, the conflict-free assessment, where you determine the low bar. Are you ill enough? Do you have enough of a chronic need to qualify for long-term care services? And then again, on the assessment, the final assessment, with regard to determining the number of hours of care. So what are ADLs? Here's a list. We're not quite sure which ADLs they're going to seize on and put into the final regs, but bathing, certainly dressing, walking or locomotion, transferring to the toilet, continence, and mobility. Those are things, eating, things that are currently looked at as ADLs. Then there are some other things that IADLs. We're not quite sure where it's going to land, but probably going to be the list on the left, the basic ADLs, which are currently in use. This is a major change as well. Treating physicians are taken out of the game. So we work with neurologists, we work with doctors treating Parkinson's, MS, all kinds of diseases, including physical ailments. The doctor will no longer be able to assist in the assessment of need with the determination of the hours of care. And in our New York City office, we use a document called an M11Q. We use it upstate as well, although it's not essential in many counties. But having a physician assessment, we think, is absolutely critical now. There's going to be an independent panel of physicians that the state is going to empower to make the determination of eligibility. So it's going from your own physician to an independent physician. They haven't identified them yet. And this is going to create, as you might imagine, lags. How do you get in to see that independent physician? How do you get that appointment, get the determination? In addition to an assessment that's going to now be done by a new independent assessor, as we're going to see in a moment. But taking the doctor out of the equation, Frank, makes it much, much more difficult. We work with the primary physicians and specialists all the time to build a Medicaid application.
Yeah, because I mean, one of the hard parts has become not necessarily the financial qualification, but it's getting that medical piece documented. So that way, when Medicaid is approved, we actually get the amount of care we need for that person in place in the home. Mm-hmm. And we rely heavily on the person's doctor typically to put in writing for us. What does this person need? What do they need help with? What are their needs currently? You know, maybe how are they looking to the future? Right? If we have to up the number of hours that person needs, if they're taking out the family physician to this independent person that's unfamiliar with mom, dad, brother, sister, wherever it is. Right now we're getting this new person in place with lots of weight probably in the middle of all this, and we can't go back to the family doctor for our help.
Whenever the state tries to standardize things, there was a uniform assessment tool that came out 20 years ago. And it was actually pretty good. It was fully computerized, and you could run it on a laptop, and you could sit with someone, ask the right questions, and get a full assessment. They scrapped it. I don't know why, but it actually worked. So we'll see how these aspects play out. The uniform assessment tool, how will that be implemented? There's going to be a new uniform assessor. They think it may be the same company that provides the Maximus evaluation, doing the actual determination of care, but a new tool, a new person or people that are going to be doing the assessment with no treating physician, an independent physician. So they basically dissociated the applicant from any of their helpers, doctors, and now it's all going to be these new uniform assessments and assessment tools. Very, very major changes, great deal of concern in terms of how that's going to impact eligibility. Right now, we do a lot of fair hearings. We do litigation in the Medicaid realm. We anticipate that's going to ramp once these new regulations go into effect, because you're not going to have any control over that medical component. One other major concern is that they put new language in dealing with safety concerns. This is always a way that they try to curtail the home care plan when it gets to be too expensive. And this new requirement requires a consideration of whether the individual is capable of safely remaining at home. Safety is raised to potentially limit high hours users. The game and the tension, the dynamic tension that was built into the managed long-term care system, where you have a group of insurers that have the money and make more money if they don't give care. That's how the system was set up, rationing care, capitated payments to those insurers. Now we have a safety concern. So if they have a high user 24/7 case at home, they can now come in and say, well, it isn't safe. So we're going to move them to a less costly setting than providing 24-hour care in the home. Frank, we always have this very big distinction, and we have to plan for it. We had to plan even more when you had no look back and no penalty for home care. But just walk through briefly the rules and the differences between chronic care and community care.
Sure. So I'm going to do my best not to mess this up because I have to kind of change my usual script when it comes to this stuff. So chronic care is nursing home, 5-year look back, penalty periods, and we generally talk about doing things like a rule of halves or promissory note planning to create eligibility. That's for nursing home, right? That's the 5-year look back that everyone's always hearing about that they're afraid of. On the flip side of that is community-based care or home health care, community Medicaid. We have lots of different names for it. It also encompasses assisted living Medicaid. Again, not something we use terribly much in the Capital District just because we don't have a lot of facilities that take it. It also does Medicaid managed long-term care through those managed long-term care insurance companies. It helps things with adult daycare, all those wonderful things that you can stay in your home, get the care you need in place. Up from now until the end of the month, there's been no look back for that. There's going to be the look back starting as of 10/1. That's why we're here. That's what's happening now.
So when you plan for someone to go on community Medicaid, you always have to have a plan B. Plan A is, okay, you're going to stay at home, you're going to hunker down, you're going to live there, we're going to get Medicaid in place, and you're going to stay in your home. To do that, we have to get you down to the Medicaid eligibility levels. But what if? You're all a banana peel away. What if you slip? You break the hip. You can't go back home. It's deemed not safe. Remember the safety rule? It's deemed not safe to be back home. Now you're in a nursing home. Well, what if you made all these transfers to get Medicaid home care, and a year later you need chronic care? Now you've got a 4-year look back still facing you. So when we build a plan, we look at the primary plan, the secondary plan, the tertiary plan, and we always have a plan. We're not going to go into all of the chronic care. We're going to focus on home care today, but whenever we do home care planning, we always have chronic care in mind because we have to get down to basically the same eligibility levels for both. Want to walk through them?
Sure. So for resources or assets, right, those numbers are on the bottom of that chart that's now on the screen. So if you're an individual, to qualify for asset purposes, whether you're at home or nursing home, you have to have less than $15,750 of countable assets. If you're a couple where you're both applying for Medicaid at home, total asset limit is $23,100. And then we have that community spouse resource allowance, which talks about if there's one healthy spouse, one non-healthy spouse. Essentially what that means is the healthy spouse can have just shy of $75,000 up to the combined spousal share of the $128,000 on your screen. Luckily, that's going away. So
that actually gets, the one thing that gets simpler
is that,
not better, but simpler, is that 74,820 number.
Yeah, that'll just be a straight 74,820 going forward in October. I think there's a slide later that mentions that.
Yes, there is.
And then when we talk about income, right, we always have to talk about assets and income. So income in the community for one person is $895 a month. Again, if we're a couple, it's $1,304 a month. And then we have that minimum monthly maintenance needs allowance. So where we have one spouse in the nursing home, one spouse in the community spouse can have their income be up to $3,216 a month.
That's called chronic care budgeting. It does apply to some waivered services programs.
It does.
So there are some community programs that have chronic care budgeting attached, but that's the additional resource allowance of $74,820 and income of $3,216 per month. But the base level for an individual, $895 a month, who can live on $895 a month and stay in your own home? We didn't even put the nursing home income allowance up there. It's $50. So if you're in a nursing home, Medicaid allows you to keep $50 of your own income. So when we get through the penalty divisor, this is a number that's going to become important as we go through our case study. And when you do a penalty calculation, you take the value of what was given away and divide it by the average regional rate for nursing home care in your area. Now, in northeastern New York, they have here $11,295. That's not the fair market rate going on right now in northeastern New York, Frank.
It is not. We routinely deal with nursing homes for our clients, and I would say the range of private pay monthly rates is usually between $14,000 to $17,000 a month, private pay.
Yeah, you're looking now $450, $550 a day.
Yep.
And plus a surcharge, 7.2% additional fee on top of the monthly nursing home charge. That's a surtax by New York State. So not many people can afford for very long to write checks for $15,000 or $16,000 per month. And New York is much higher than most other states. There are a few other states higher, but New York has a high rate. This is a rate that was taken and used by New York because they said they couldn't get data for every private pay nursing home. So they basically took the Medicaid reimbursement rate and multiplied it by 120%. That's the $11,295 number. So you can tell what the Medicaid reimbursement rate is because this is 120% of it. So when we do a penalty calculation, Frank, you take what's given away and you divide it. So run through this one.
Sure. So in this example, right, we're transferring $135,540, and we're saying that we're in the Northeast region just because that's where our office is. We know those numbers by far the best just because that's the ones we deal with the most. If we do an application before 10/1/20, there's no penalty, right? We got those transfers done before the new law took effect. They can't penalize you for what you did prior to the new law taking effect. That's why 10/1 is so important. That's why we're under the gun to do all these things. If we don't make 10/1 and we actually have to apply as of 1/3/21, so now we're into next year, we're into this new normal, if you will, then if we still made that transfer, then we are looking at a potential penalty of 12 months if that transfer was made after the 1st of October.
Now, you might ask, and rightly so, what happens in that 3-month hiatus between October 1st and December 31st? What we're led to believe from the Department of Health is that as of October 1, there will be a look-back period, but they're not going to impose it until January. So if that's true, and we believe it is, what that means is if you do apply in November or December, we do not believe that there will be imposed a look-back period. So if you apply in November and there is no look-back period, you don't disclose any transfers, even if they're made in October. And if you apply in December, even if they're made in November. So we believe that there is going to be a 3-month grace period, if you will, for applications filed during that period. But once you get to January and you file your application, then there will be a 3-month look back going back to October 1st. So again, the critical dates are for transfers, October 1. For applications, it looks like January 1. Right? So this is another piece for home care that I mentioned earlier, which is very difficult to ascertain. It begins to run when you're otherwise eligible, which means that but for the Medicaid rules, you would be receiving home care and eligible to receive home care. If you have a transfer penalty, there's going to be a waiting period. But how do we interpret this rule? And how do we look at the look back period, Frank, going forward from January? Is it a 30-month look back in January?
No, at least that's what we're being led to believe, right? We're essentially, once we're into January, the look back is phased in, meaning they're going to look at everything you did from the month that you're applying back to October 1, 2020, this year. And if you made a transfer within that limited window from month of application back to October 1st, 2020, that's what they can penalize you for. So it's going to have some interesting ways of looking at all this stuff because we have all of these different time periods going around, right? When did we apply? When did we transfer? When did things get moved? All those things. We have a lot of dates flying around.
And there is precedent for this. Frank was still in high school, but in 2006,
I graduated in 2005.
He's a cop. In February 8th of 2006, new rules were implemented from the Budget Reconciliation Act of 2005. And that's when we got a 60-month look-back period. It went from 36 to 60. And the imposition of that rule was a phase-in. So it didn't start as a 60-month. It started as a 37-month look-back, then 38, 39, 40, et cetera, up to 60 months phased in so that it did not affect people who were applying prior under the old rules. They're proposing, we think, wait for final regs to give you a final answer. But we think that they're going to phase this in so that in January, again, there's a 3-month look back, February, a 4-month look back, all the way up to May of 2023, which is when you would have the full 30-month look back. So remember, transfers made prior to October 1 don't have any penalty regardless. But if transfers are made subsequent to October 1, beginning in January, they'll get hooked in and pulled into the transfer penalties. And then you have to navigate the transfer penalties for home care the same way you did for nursing home care. One difference, as I said before, when you're in a nursing home, you know it, right? You're in 4 walls, you're in a bed, in a room, and it's in a nursing home. If you are at home, how do you determine that you are medically otherwise eligible for Medicaid? They're not going to send out a team to do assessments in order for you to simply run the penalty period. How is this going to be done? Our best information, and again, this is from DOH in an informal presentation, but it's our best information to date, that for this purpose, you will be able to use the treating physician. And you will be able to determine Medicaid eligibility from a treating physician's affidavit. And then you can run the penalty because you have to be eligible for Medicaid, be financially eligible, and eligible from a medical perspective. You have to hit both prongs of the test. Then you apply for Medicaid, then your penalty runs. It doesn't run automatically. It simply hangs in limbo. So if you gift assets away in October and you apply next October, when does your penalty period start, Frank?
Do that one more time for me. So I'm sorry.
You give assets away in this October,
Yep.
in 2021 October, you apply for Medicaid. When does the penalty period start to run?
When you apply.
October 1 of 2021,
When you apply.
not 2020. So this is a critical factor. You have to establish eligibility financially and medically. We think a physician's affidavit is going to be used to trigger the medical home care eligibility. But remember, now it's a new standard. So that doctor has to understand 3 ADLs or the cognitive impairment rules under the new medical criteria. All new stuff, a lot to learn, a lot to keep following with final regulations, but this is the game that we're in. So it's very important, Frank, to remember that even for nursing home Medicaid, when you give assets away, there are certain transfers that are exempt.
Right, which we use all the time because sometimes we have these other planning opportunities where we can do some things where we don't have to worry about the penalty period. So if you have a spouse that's doesn't need Medicaid alongside of you, right, you can transfer things to your spouse free of penalty. If you have a disabled or blind child or a trust for the benefit of that child, you can transfer free of penalty to that child or that trust. There's also sole benefit trusts. We don't use them very much just because they have very stringent rules. But again, if that's the best avenue to use, we can use that as a way to get things away from you free of penalty, where we don't have this penalty hiding in the background for you.
Most people know that you can transfer spouse to spouse, and there's no penalty on that. Remember that for later when we start talking about spousal refusal. The disabled child exception we use more and more frequently.
Right, I literally got out of a consultation this morning where I had a daughter who had a disability in her past. Her parents are in needing of some help, and luckily we have a good planning opportunity that we can either try to get things done by the end of this month, and if we don't, because something crops up, we can always gift free to that disabled child, and then it doesn't matter when mom or dad needs Medicaid because they can't penalize them for that transfer.
So a disabled child is someone who is receiving Social Security disability or supplemental security income or even a veteran's disability. all of those will qualify, and a parent can transfer an unlimited amount of assets to that disabled child, and it is not a penalized transfer. There are other rules, Frank, that we use but are remedial in nature. These are not planning opportunities. This is if you need to fix something. The toothpaste is out of the tube and you're trying to put it back in. If assets were transferred, but they were really transferred for full consideration, full fair market value, that asset was sold, not given away. The burden of proof is on you to prove that you received full fair market consideration, but if you can meet that burden of proof, then that's an exempt transfer. It's not a gift, it's a sale. In addition, if you gave away assets exclusively for a purpose other than to qualify for Medicaid, and I've done fair hearings on this, I've actually done litigation, Article 78 on this, you have to establish your facts and you have to prove that you were healthy, that you were making the transfer for a very different reason. Medicaid was never in the picture, and you can't get the assets back, basically. Under those circumstances, there's an exception, a hardship exception, if it's done for purposes other than to qualify for Medicaid. And one that we're going to talk about more in just a moment, if assets are given back. So if you've transferred things and they're gifted back, that erases the penalty. Another brief poll. Under the new rules, the best way to qualify for Medicaid home care is, and choose one of these: give away 100% of my excess resources outright, use a gift and promissory note strategy, we're going to get to that, tell my spouse to move out of the house and refuse to pay the government a dime, spend down my excess assets for the next 30 months. Each case depends on specific factors and circumstances and requires careful evaluation.
I'm curious where this is going to go.
So if you could mark one. All right, pencils down. Our survey says everyone is on track.
It's disappointing.
All of those are planning techniques, except for the one about my spouse moving out. But spousal refusal is a legitimate planning technique. Every situation is different. And if you're married or single, plans are very different. If you're single and have children and you have an ability to do it in advance, it's different. If you have very limited resources, it's different. So each case is going to have unique facts and circumstances. We're going to talk about a few of those in our upcoming slides. But when we do this, sometimes it's better to have it in context. So we're going to talk about Bob. What about Bob? This. Bob has a monthly income of $3,442. He has assets. We call them non-exempt assets. So this doesn't count his home because the home is exempt. Doesn't count his IRAs because his IRAs are exempt. That's a whole nother presentation. We'll talk about our other presentations at the end of the program. Home health care costs of $9,000 a month, about $108,000 a year. What does that get you? What does $108,000 a year get you? If you're hiring an agency at $25 an hour, 12 hours a day, $300 times 30 days, $9,000 a month. There's your $108,000. What does that tell you if you need 24-hour-a-day care? Double it. Go to $218,000, and we have people paying $250. We have clients with the wherewithal, the resources, and for 24/7 care on a private pay basis, they're paying $250,000 per year. So Medicaid home care is a pretty important program because it helps clients stay out of bankruptcy and have resources to use. So Frank, what can they do?
So we did we talked with Bob's family. We suggested doing some pre-planning, right? We had them prepay his burial. He needed a television. He needed some clothes. We put some technology in the house, some furniture, and of course he paid his legal fees. So we got some money out of his name. We got him down a little bit lower to $228,750. And then we did our promissory note and gift strategy, which we have done videos on. So you can certainly go back in the library and see those. So essentially what we do is we gift $135,560 to his son or some other family member. And then we loan $77,439, again, to the son to get these assets away from Bob in a way that does create a small penalty, but it also gets him qualified for Medicaid after a period of time.
Now, Frank, this is a technique we've been using in nursing home cases for a very long time.
Yes, this is the planning technique that we use. If you haven't done any pre-planning and then someone needs a nursing home and we need to do things when there's a crisis, when we haven't done plan to get through that 5-year period.
Yeah, and you can do this even for people already in. I've had clients come to me that their parent was in the nursing home for a year, 2 years. They've already spent a couple $100,000 and they have a couple $100,000 left. And they say, can we save anything? And the answer is, yeah, you can save a little more than half in most cases. They call it the rule of halves, or half a loaf. And the details we're going to unpack a little bit, but remember that critical dates, transfers of assets for home care purposes prior to October 1, no look back, no penalty. Home care applications after that January date, then you're going to have the look back and the imposition of a 3-month look back with penalties on any transfers made during that time period, with a rollout or a phase in of the look back period. So with that, here are the calculations.
So here's what we did, right? This is what Bob got from doing all the planning. We look at his income. He's allowed that 895 number that I talked about earlier. So he's got 2547 left over.
Excess income.
Right. So we plan on using that in our calculation. So we need to make up a shortfall of $64.53 a month, because we have that home care cost of $9,000. He brings in money every month. We got to take that into account. We look at his non-exempt assets. Again, we spent them down some. He's allowed to keep $15,750 again from the earlier slide. So his at-risk number is $213,000. So we do all of our calculation. We gift half, we loan half, or we use those numbers from the previous slide, and then we put it all together, and we basically construct a loan that pays back to Bob once a month for the period of time that he's ineligible to receive services at home. That way he has money to privately pay for those services in the home until that penalty runs completely, and then Medicaid steps in to help.
So the key is to gift assets, preserve as much as you can, keep or have as much as you can, as you need, rather, flowing back to pay for care during the period of ineligibility. And then at the end, have the promissory note, which is paying back to pay for care, and the penalty period, which is running during that entire time period, expire on the same day. So that at the end of that, the note is gone and Medicaid kicks in and will pick up the cost of care. For nursing home care, this is a much more certain game, because you know what the nursing home cost is, and you know that you're in a nursing home, and you can trigger the eligibility. So it's a little bit more of a complex calculation for home care, but it does work.
So if you use the numbers from the earlier slide, we give that gift of $135,560, divide that by our penalty number, that $11,295 for the Albany region, that gives us a 12-month period of ineligibility, that 12-month penalty. That loan that we gave Bob Jr., it's calculated out to give him exactly $64.53 a month for 12 months. That covers his shortfall of what he needs to pay for his care privately. So after that 12-month period is over, that's when Medicaid picks up. But again, we got to look at numbers and timing of all of this, right? When did we apply? If we apply in January, or now we have that 3-month limited look back to October 1st, then they are going to see that transfer of the $135,560. They're going to penalize Bob for that 12-month period. And then they're going to impose the penalty. The penalty starts running. Hopefully we get that stuff, that documentation from the doctor to show that he medically needed those services. Right? The penalty runs, and then when the penalty is over, the note also ends, and now Bob's eligible for Medicaid. Medicaid will start paying for him January of 2022.
So what's left?
What did we do? We saved a lot of money for him. We put at $135,560. We gifted to his family, which they put into a trust. He also had his $15,750 allowance. We got his burial prepaid, and then we also bought the furniture, TV, all those wonderful things that we did prior to even putting any of this in place.
And then, Frank, what happens on January 1 of 2022?
Then Medicaid starts coming in. They start paying for the care that Bob needs. So that way, at that point, now he has his income coming in. Now he doesn't have to use it to pay for those home care services, because Medicaid's going to do it.
Okay. So the income is a major issue, and the 895 is a tough number to live on. So people have used a pooled trust. They call it a pooled income trust, and you can divert your income over the allowance, over the 895. It goes into the pooled trust. You give the pooled trust trustee bills. They pay the bills. So you can pay mortgage, taxes, food, utilities, rent, clothing, anything for Bob. Any expense that Bob has is a legitimate expense and can be paid out of the pooled income trust, but it allows Bob to keep his income in the game, paying for non-medical services while Medicaid picks up the cost of the approved hours of home care. There is an open issue with this legislation, the budget bill, as to whether pool trusts can continue. And pool trusts for people under 65 are always allowable. If you're under 65 and disabled, you can use a special needs trust or a pool trust. We have in New York the privilege, really, of using the pool trust for people over age 65 to protect income, not assets, but income. And so up until now, there was no transfer penalty for home care. So you could put income into this pool trust and have it utilized back to pay the bills of the Medicaid applicant. But now there is a penalty. So is this transfer of the income of 2547 into the pool trust a transfer every month that will be penalized? Again, our best guidance from the Department of Health is if that money is utilized from the pool trust back for Bob's benefit, then it will be an exempt transfer and it will not create a penalty period for Medicaid home care. So you have to make sure that the money goes in and it comes back and gets used for Bob. A lot of clarification is needed here. One of my colleagues and my partner in a company called Elder Counsel is Vincent Russo, who operates a pool trust, the Teresa Foundation Pool Trust that we have utilized in the past. He's doing a very deep dive into this issue and will be coming out with a memo, and we hope to be able to share that with you once it's done on the use of pool trusts under the new regulations as they come out. So will a gift and loan work? Yes, but there are challenges, and we've talked about those. Financial eligibility and medical eligibility determined, we think, with a physician affidavit to trigger the penalty period. Once the trigger is done, then the rule of halves works well, except you have fluctuating needs and fluctuating expenses. So how do you make sure that your note payment isn't too much or too little? And here's a chart which kind of analyzes the different rules, nursing home versus home care. I'll leave that for you to study. We've covered most of this chart already, but the rule of halves transfers for home care have those unique challenges, triggering the penalty and quantifying the expenses. So as we're looking down the road at how we're going to plan for people who want to create Medicaid eligibility, we just covered the gift promissory note strategy, but in home care, what we're probably going to do is create a side fund so that we have a little bit of leeway and wiggle room where we have a little bit of extra money that could either be gifted back to shorten the penalty or could be used to pay additional expenses if the cost of care becomes more expensive. You can always gift 100% of the assets outright. A lot of tax consequences to this, so we don't recommend it unless it's just cash. But if it's cash, you could just gift it to the kids and have the kids pay the bills while the penalty period runs until the two time periods meet. For people with significant resources, you're going to gift an amount over what you need to pay for that 30 months. So we'll be doing a budget for 30 months, keeping enough in the game to pay for that, and you don't have to do the promissory note. You're just going to private pay and wait for the look back period to run. So significant amounts of assets, the 30-month look back, you will private pay for care during that time and then apply for Medicaid and then spousal refusal. So these are the fluctuating factors, Bob's expenses, the note payment baseline, and then a side fund. This is plan A to pay bills. And these are, again, works in process because we don't have final regs yet, but the other is to just gift 100% if you have kids that you trust and you know that they'll use the money back for you. You can just gift it and they can use it. And as they use it, as they gift money back to you to pay those expenses, it reduces the penalty period. So you start with a longer penalty, twice as long, but then reduce it by half through gifting back. And then you always have just pay for 30 months and gift the balance. And that just takes some budgeting to know what your cost of care is going to be and setting aside enough income and assets to private pay for 30 months. And then, as I mentioned, spousal refusal. If one spouse only needs Medicaid, the well spouse can be gifted all the assets. They can file a spousal refusal, and that spousal refusal would allow them to keep those assets and get Medicaid started immediately for the other spouse. We mentioned the income and asset rules. You have to be aware of those and know which programs give us the chronic care budgeting, that $32.16 a month. And if the spouse themselves has income over that, they're asked to contribute 25% of it. So there are resource and income allowances, but spousal refusal in New York was preserved. The governor has put it in the budget bill to eliminate spousal refusal for the last 27 years, and they're over 27. So we still have spousal refusal with us for a variety of reasons, and it's simply saying no, refusing to turn over the assets, transferring assets to the well spouse, and then applying for Medicaid home care for the spouse in need, and eligibility will kick in at that point in time. Well, what does the spouse do with those assets once they have them in the community? Well, we want to do a little further planning, because the county can come after you and the state can come after you and seek contribution toward the cost of care. That's typically done either in a family court or a Supreme Court action. We've defended a number of these, and it is something that certain counties will pursue. If there is spousal refusal, they will pursue the refusing spouse for excess income or resources. So the spouse would want to do a trust and do the Medicaid trust plan once the other spouse is deemed eligible. Frank, timing in all of this is critical. Yes. And how do you get the services in and know that they're going to be paid for? This is something we already face critical delays in many of the places. We do MedApps in Long Island, in New York City, all 5 boroughs, and all of upstate New York. Time frames.
So on top of just getting all your numbers to work out, right? Once we get everything worked, placed, transferred, whatever we're doing properly, then we have to actually submit all this paperwork to the local county office. And then it's on the county to process these applications. And like Lou said, we deal with counties all over the state, and in none of them have I ever heard a county worker say, you know, I'm really glad this application came in. I had really nothing else on my desk to do. They're very wonderful people who do a very needed service, and they're overworked already, and it's going to get worse because now once this look back goes in place for home care, now they got to audit financial statements for every Medicaid application that comes across their desk instead of just a chronic care application.
And don't forget the independent physician examination and the independent assessments and all of the things that are going to have to be done in conjunction with the application. We had all these problems under the MLTC, which is what the Medicaid redesign team, or did for us. They gave us the MLTC program. And so we've been dealing with those delays and the fights and the fair hearings to establish the number of hours of care. So they enacted something called the Immediate Needs Program to fix the MLTC program. So immediate needs is now in jeopardy because now you have all of these additional requirements. So how does an agency, a county DSS, who's now doing the whole processing of the immediate needs application in 12 days, how do they do all of that paperwork? Well, one of the things that they're proposing is that the county accept verification. So instead of going through all of the documentation and a 30-month look back to establish the immediate needs application, accepting a verification and then doing a background, going back to it and verifying that those numbers are correct. So immediate needs is something we've relied on for clients coming out of the hospital. They need to get back home. They can't wait 90 days to get a Medicaid determination. They need services. And the immediate needs program has been a godsend for those clients. And counties have been wonderful at implementing it and trying to stick to that very rigid 12-day timeline. But with all of these new requirements, we'll see how DOH rolls them out and what they're going to accept in terms of just verification as opposed to documentation of every account and every transfer. And so that will be something to watch coming forward with the final regs. How do you put all of this together and counsel people through this new morass of rules and regulations where we had a once fairly simple system from a financial eligibility perspective? It was very complicated from a medical and care perspective. Now we have the finances with a 30-month look back and all of these rolling out rules. So get a quality assessment. Quality elder law attorneys, the National Academy of Elder Law Attorneys, we're members. Also, we are members of Elder Council, actually the founder of Elder Council, and Elder Council attorneys get highly trained in these areas. We're doing webinars for them and education for them all the time, but make sure you get a quality elder law consult. Certainly in any of our areas, which is most of New York, we can help, but get a good quality elder law consult. And we recommend using a care manager to do the assessment piece, because how do you know? Now we have all of these rules. Are they eligible? What program is right? We have care managers on staff, Nora Barato, Susan Bale, who work with our clients to help us be informed and know which Medicaid programs that we want to use. So the care assessment, the legal assessment go hand in glove in our minds. And we don't really think that an elder law attorney can function without having that care be assessed by someone who's a professional who can then inform the entire Medicaid application process.
I couldn't agree more, because there's so much we can do as attorneys. There's a lot of things we can't, because we're not social workers, we're not medical professionals, but they are people that do those types of things, and that's why we have them here.
So next steps. For anybody contemplating planning, now's the time. Get your trust done, get your transfers done prior to October 1. Again, we have other webinars, we'll put it up on the screen in just a moment, that go through all of the trust planning and how that's done. We're happy to sit down and do a consultation complimentary for people who are referred in and have watched our webinars. Medicaid asset transfers should be done by October 1st to get in, avoiding any type of look back. We think we have now until January 1 to file applications. We'll wait till the final regs to make sure that's the case, but that's what we think now. But in any event, getting started now is absolutely the key. And I mentioned that on our website, we have videos on our library. We did webinars on Medicaid, long-term care, trust planning, estate planning, etc. We invite you to use them. They're free of charge. We've tried to give as much content as we can. We think they're pretty content rich, but you can just go to pierrolaw.com and go to videos. Or if you want to see what we have coming up for events, you can go to events. And then we have guides, blogs, and other information on our website. Our final poll of the day. I'd like to discuss Medicaid planning with a qualified attorney. Again, it's complimentary. If you'd like to speak with myself or Frank about a Medicaid issue, a Medicaid case, we're happy to talk to you. We can set up a video conference, a telephone conference, an in-person conference. Any of those are available at this point in time. Socially distanced, masked, if it's not socially distanced. So we're following all the protocols. And if you'd like to discuss your care needs with a qualified care manager, we would be happy to invite that as well. So if you would fill that out, we're not going to put the answers up to this one, but we would like to know if you'd like to get in touch and talk about the Medicaid rules or any aspect of elder law or estate planning. So go ahead and fill that out. Don't cost nothing, as they say. And with that, we are done with the formal portion of our presentation. We are about a minute or two over. We do have some excellent questions. If you want to hang for 5 minutes, we'll take a few questions. We will answer any questions that we don't get to on air in an email. Beth?
All right. What exactly is meant by a look back period? What are you looking for?
So a look back period is a period of time where the county would do an audit on your financial accounts for a given period of time. So let's use January 2021 as our example, right? If the look back starts October 1st, 2020, and we're starting and we're applying in January of 2021, then what they're going to do is they're going to require with any application for home care that we give financial statements for any financial account you've had in that time that cover October, November, December, and then showing the balance as of January 1st. And then essentially what they do is they track every transaction for more than $2,000. And they require an explanation of where did that money come from, or if it was moved, where did it go? And if it went to somebody other than a spouse, disabled child, anything like that, then they will impose that penalty period, because essentially what you have done is you have given your funds away instead of keeping them where you could then use those funds to pay for your long-term care. And
Again,
that's why you get penalized.
the existing home care rules, there's no look back. It's going to be phased into 30 months. Beth?
So you may have just covered this, but could you define, quote, transfer? If a person withdraws a large amount of money from the bank, but does not gift it to anyone, is that an issue, or is it transfers to someone else?
If they draw it out, where are they putting it? Are they putting it in a coffee can, burying it in the backyard, or are they giving it away, paying people? We see transfers made in 100 different ways. Anything where you have shifted it from your name, they will audit that 30 months. For nursing home, they're going to audit 60 months. And it's an audit. For you DSS workers still on the line, you do a great job. This is worse than an IRS audit because they're looking for every canceled check over $2,000 in most counties, and they're going to penalize that transfer. If you withdraw from the bank $50,000 and you don't have receipts and you can't show where it went, it's a transfer. It is a presumed gift. Next.
All right. When you mention home care application, are you referring to Medicaid application with an immediate needs attestation?
If it's immediate needs application, it would have that immediate needs attestation and verification from the doctor and the other forms we need for that. But in this context, there are home care applications that don't necessarily meet that, or we're not applying for immediate needs in every case. We do it a lot, but it's not necessary in every case.
What we believe is that if you have done any type of asset transfer, you're not going to qualify for immediate needs. So if you have truly nothing, you have no assets, and you need care right away, you'll qualify to apply for immediate needs. But if you had 100,000, you gifted 50, and you're going to use 50 to private pay, we don't believe that that's going to qualify for an immediate needs application. So that's a standard Medicaid application, which right now is a managed long-term care application, unless you're going for the
NHTD program,
Nursing Home Transition Diversion Waiver Program, which is a separate application.
How will these changes affect someone with a long-term care partnership plan or long-term care insurance?
It won't, because under the partnership, your assets are already exempt. Once you exhaust your insurance, the partnership says 3 years. They actually have some policies, 2 years of coverage for nursing home, 6 years or 4 years for home health care. Once you've gone through your benefit, then your assets are fully exempt for Medicaid purposes. You don't have any transfer. You don't have to transfer. You can keep all your assets, or you can give them away. There is no transfer penalty. So the partnership exempts you both from resource and transfer rules under Medicaid. Most people don't have a partnership policy. You can't buy them anymore. If you're looking for them on the market, no company offers it in New York right now. And hopefully they can bring something like that back. But right now, there's a little void in that market. Other long-term care insurance policies, traditional policies, we often combine trust planning with the policy. Then your assets are exempt and you still have the insurance coverage.
What is the reasoning behind forcing clients to see a new physician? That could put a client behind for months.
Good question. We asked the same question. And it's a doctor that has no history. And if you go through a hospital right now, you know that you go through a hospitalist, an internist, intensivist. Your doctor doesn't have any say, and the care doesn't track with you. It's not the same because they don't know you. So now you're going to an independent physician who has no history, who's going to do an IME, an independent medical exam, and try to come up with a recommendation as to home care. It's a disaster waiting to happen. We'll see how it plays out.
Are there any negative consequences when doing spousal refusal for the healthy spouse? Say they end up needing Medicaid for themselves in the near future or in the future.
So yeah, when you have this shift of assets, then you want that spouse with the assets, the healthy spouse, to do their own planning. We have to wait until eligibility is established. So you transfer the assets, you apply for Medicaid, whether it's nursing home or home care now. And once that application is approved for the Medicaid applicant spouse, then the spouse with the assets can do their own planning, can create a trust, can transfer the assets. Now we still have to play all the rules, 5-year look back, 2.5-year look back, but we're going to do Medicaid planning for the spouse with the assets. The risk is they get sued by the state and the county seeking contribution, and we will always plan, what if that spouse dies first? We have a plan for that. So plan A, B, C, and D go into effect.
All right, based off this information, when you suggest NHTD and TBI state waivers will not be affected, does this mean they will continue to utilize the same Medicaid eligibility guidelines as they do presently?
That's what we're led to believe, yes.
Okay, and we've got one more here. Let's see. Are these proposed changes only for individuals seeking home care services via community Medicaid, or is the 30-month look back also going to impact Medicaid eligibility for community Medicaid in general?
Only long-term care, not just health benefits. A lot of people rely on Medicaid for primary health care. These rules are applying to long-term care services. Thanks for joining us today. Thank you, Frank.
Thank you.
See you next time.